Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast. I'm your host, Grace Gottschling. On May 11, 2020, the U.S. Supreme Court heard oral argument in the consolidated cases Our Lady of Guadalupe School versus Morrissey-Berru and St. James School v. Biel, which involves a dispute over whether the First Amendment's religion clauses prevent civil courts from adjudicating employment discrimination claims brought by an employee against a religious employer when the employee carried out important religious functions. Back in 2012, in the case Hosanna-Tabor of Evangelical Lutheran Church and School versus the EEOC, the Supreme Court unanimously held that under the First Amendment's religion clauses, quote, it is impermissible for the government to contradict a church's determination of who can act as its ministers, end quote. Accordingly, the court recognized that there is a ministerial exception that precludes application of employment discrimination laws to claims concerning the relationship between a religious institution and its ministers, leading to the question of who qualifies as a minister. The Hosanna-Tabor Court refused to adopt a rigid formula, but found that the employee at issue in the case was a minister in light of several considerations, including the formal title given to the employee by the church, the substance reflected in that title, the employee's own use of the title, and the important religious functions the employee performed. 8 years later, the question of who is a minister is back before the court in Our Lady of Guadalupe v. Morrissey-Berru and the St. James School v. Biel. In each case, teachers at Catholic schools brought discrimination claims, and the Ninth Circuit concluded the ministerial exception did not apply. Now, before the Supreme Court, the schools contend that the Ninth Circuit has adopted the rigid formula that the Hosanna-Tabor Court eschewed, and they argued that in most cases, a religious functions test is sufficient. And now, to discuss the case, we have Nathan Chapman, Associate Professor of Law at the University of Georgia School of Law.
Hi, I'm Nathan Chapman, Professor at the University of Georgia School of Law, and I'm going to talk about the oral argument in Our Lady of Guadalupe School versus Morrissey-Berru, a case that tests the limits of the ministerial exception. Before I get started, I should disclose that I joined a number of other scholars in a brief supporting the petitioners in this case. So the case is about whether or not teachers, specifically lay teachers at Catholic schools, count as ministers for purposes of the ministerial exception, even though they don't have the title minister. The court articulated the doctrine of ministerial exception in 2012 in a case called Hosanna-Tabor versus EEOC. In that case, a teacher at a Lutheran school who did have the title of minister by virtue of some training and who taught some devotional religion in the school and also led students in prayer and such, sued for discrimination in her firing. And the court held that churches and other religious organizations are protected from anti-discrimination suits in hiring and firing ministers. And so the question in Our Lady of Guadalupe is whether or not the same immunity or exception applies to religious schools who make hiring and firing decisions of teachers who don't have the title minister, but who have pretty much all of the same functions as the teacher in Hosanna-Tabor. The schools here are arguing that function should be everything in determining who counts as a minister, and they propose a test that the court ask whether or not an employee has, quote, an important religious function. They argue that limiting the exception to where a employer has deployed a formal title of minister on an employee would discriminate among religions because not all of them use the same nomenclature for theological reasons, even though the employee may have exactly the same function within the religious organization across organizations. The teachers argue that empirical factors like titles and perhaps educational requirements or belief requirements or something like that should be the most important, but they concede that function can play a role, at least in some cases. Since neither of the sides argue for a bright line, you can imagine that much of the oral argument was spent trying to push them for limiting principles, and the justices predictably used a number of hypothetical cases to try and figure out how lower courts are going to respond to their various proposed tests for determining who counts as a minister. And it's important to keep in mind that the court was unanimous in its decision in Hosanna-Tabor, and in fact, Justice Alito wrote separately, joined by Justice Kagan, to emphasize that courts should apply a principally functionalist approach, and lower courts have tended to follow that as a guidepost for determining who counts as a minister. And so it's not at all the case that there are members of the court who are generally unsympathetic to the ministerial exception as a doctrine. The real question here is whether or not it extends to teachers like these who do not have the title minister. One of the most notable exchanges in the argument was between Justice Kagan and the lawyer for the schools, in which Justice Kagan went through a series of short hypotheticals asking for more or less a thumbs up or thumbs down as to whether or not this person would count as a minister under the, quote, important religious function standard. And one thing that came out from that exchange, I think, was that the schools are arguing that their limiting principle really is that there can be such a thing as de minimis religious engagement between a teacher and the teacher's class, or a coach and students, or a nurse or something like that. Sort of going through a very rote prayer or something like that at the beginning of the day is probably not enough to, turn a teacher into a minister. But on the other hand, a nurse whose job duties entail the spiritual formation or spiritual leadership and praying with patients, which is, I think, a relatively unusual job duty for most nurses. But if that's part of the job duty, then it might well mean that the nurse counts as a minister, and the ministerial exception applies. The U.S. entered the case on the side of the schools, and the Assistant Solicitor General was at pains to emphasize that a functionalist test is necessary to ensure fairness across religious denominations and religions that have different ways of thinking about who ought to count as a minister, but all of whom should be entitled to the same protection as the Lutheran school in Hosanna-Tabor. When the justices pressed the teacher's attorney on this point of fairness among religions, he had principally two responses. The first was that the courts should generally defer to the kind of hierarchical decisions and the religious decisions that religions make with respect to titles and objective empirical indicia of whether or not someone is a minister. And in the second place, expanding the exception, as he put it, to include lay teachers would have sort of a parade of horribles, would result in a parade of horribles where virtually every lay teacher in the country would be considered a minister, and so would perhaps nurses in hospitals, camp counselors, and the like. And really, I think the teachers were pushing for a vision of minister as a paradigmatic example being a sort of clergy member who leads a congregation or a parish, but it didn't have much of a response for the fact that the teacher at issue in Hosanna-Tabor, where the court unanimously held the ministerial exception to apply, wasn't a congregational leader or even trained to be a congregational leader. The title minister was something kind of unique to that denomination that they used for some teachers and not others. Based on the argument, I think it's quite likely that the schools will win in this case, that there'll be a majority of between 5 to 7 or 8 willing to say that the ministerial exception applies in one or both of the two cases that were consolidated here. But I think it's less clear whether there will be a majority that comes to agreement on the rationale or the proper standard that the courts should use going forward. It seems clear that Justice Thomas and Justice Gorsuch are inclined towards the concurring opinion that Thomas wrote in Hosanna-Tabor, arguing that courts should generally just defer to a religious organization's sincere belief that someone counts as a minister for purposes of the exception. The idea there is that it simply entangles courts too much in internal religious judgments to deciding who counts and who doesn't count as a minister. I think it was pretty clear that Breyer and Kagan are searching for a test that courts can apply. And Kagan in particular, I think, seemed sympathetic to the fact that the teachers in this case were responsible for teaching devotional Catholic theology and leading acts of worship. I think she's maybe less sympathetic to a coach or science teacher at a Catholic school who just leads students occasionally in prayer or something like that as counting as a minister. Breyer may be inclined to something similar, and so it'll be interesting to see how they attempt to draw a line that accommodates those inclinations. Justices Ginsburg and Sotomayor seemed more sympathetic to concern that expanding the ministerial exception here will result in a major gap in anti-discrimination coverage, and seem more likely to want to hang their hat on whether a person is titled minister or perhaps is required to have some kind of special training or has, in fact, some special training that might enable them to distinguish this case from Hosanna-Tabor. Roberts appeared to me to be the most reserved in his views of the issue, but his questions tended toward the center or perhaps the center right of the debate. He seemed to be concerned about how the court can do a ministerial exception analysis without engaging in religious judgments. And he also seemed to appreciate the fact that a more formalistic analysis is likely to have the effect of shaping the way that religious organizations frame their employment relationships in order to qualify for the exception, rather than actually changing the results in very many cases. So I predict a pretty clear win for the schools, although, like I say, I think it's unclear at this point whether we'll come out with a majority that agrees on a clear rationale or a clear standard.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.